You are listening to Based in Fact, a true crime podcast. Join hosts Lisa O'Brien and Kyle Evans as they examine America's most infamous true crime cases as they were established in our courts and the basis for the decisions of the appeals courts, not the court of public opinion. Here's Lisa and Kyle.
Welcome to Season 3 of Based in Fact, a true crime podcast. I'm your host, Lisa O'Brien, and I'm joined today by Robb Chadwick, a former journalist with a lifelong interest in the truth of true crime and fairness for victims. Since his retirement, Robb has researched and written about a number of cases, but none more than our case of the day, the murder of Hae Min Lee by Adnan Masud Syed. This is episode 14, State of Maryland versus Adnan Masud Syed. On January 13, 1999, Hae Min Lee disappeared after leaving Woodlawn High School, where she was a popular athlete and scholar. Police looking for her questioned several people, including her current boyfriend and ex-boyfriend Adnan Syed. On February 9, 1999, Hae's body was found partially buried in a shallow grave in Leakin Park in Baltimore City, Maryland. 3 days later, on February 12th, an anonymous tip led police to put Adnan Syed at the top of their suspect list. On February 27, 1999, Jay Wilds, an acquaintance of Syed, was interviewed by police, and early on the morning of February 28, 1999, led police to Hae's missing vehicle. Syed was arrested, convicted, and sentenced to life plus 30 years in 2000. The case has been the topic of multiple podcasts over the years, and in 2022, his conviction was vacated by a pro-defense judge in a fixed hearing at which no one represented the interests of Hae Min Lee or her family. On August 30th, 2024, the Supreme Court of Maryland affirmed the Appellate Court of Maryland's reinstatement of Syed's conviction and held that Hae's brother, Young Lee, had the right to be heard at any future hearing seeking to vacate Syed's conviction. And welcome. Happy Sunday, Robb.
Thank you, Lisa. Thanks for having me.
Thank you for being here. Kyle is off, I think, attending to either business or family. So
Okay.
Robb graciously agreed to join me, and thank you so much for being here and spending your Sunday with me.
Oh, you're quite welcome. I enjoyed it.
All right, so we're going to talk about the atrocious vacator procedure in the Adnan Syed case. That's going to be the focus. But in order to do that, we're going to start off with a little thumbnail view of the case against Adnan Syed. And of course, we start with our victim, Hae Min Lee, who was born October 15th, 1980 in South Korea. Her mother is Yeonhwa Kim. Her brother is Young Min Lee, and they moved to the United States in around 1991 or 1992. Hae was an honor roll student at Woodlawn High School. She was a member of the varsity field hockey and varsity lacrosse teams. She managed boys wrestling. She was a member of the Ecology Club, the French Club, and SAD, Students Against Destructive Decisions. She also worked part-time at LensCrafters. Robb, do you happen to know what she was doing there? It never
So
mentions what she did.
she was doing sales. She was out on the floor, fitting glasses and that sort of thing.
Okay, thank you, because
Well,
not one of the articles mentions what her position was.
and she was part-time sales.
hmm And her cause of death was manual strangulation. Then we have the perpetrator is Adnan Masud Syed. He was born May 21st, 1981. Some records also list his birthday as May 21st, 1980, in Baltimore, Maryland. His parents are Syed Ramen and Shamim Ramen.
Shamim, yeah.
His brothers are Tanvir Syed and Yusuf Syed, and apparently in the um, South Asian cultures in Pakistan, India, they take the father's first name as their last name.
It's interesting because in Rabia's family, the Chaudhrys, they don't do that. But yeah, in the Rahman family, Syed is the father's first name,
Mhm.
and his last name is Rahman.
Yeah. And I've seen some things that list the wife as Shamin Syed instead of Rahman, but
Hmm.
um, he was also a student on the honor roll at Woodlawn High School. He was a member of the football and track teams. He was a part-time paramedic. The stories claim he was a volunteer, but he was not, and he should not have been doing that job because he was only 17. He was not 18. So even for his part-time work in high school, he was trying to get over on somebody.
Yeah, the whole teenage. I mean, if you look at his whole life, he's been running a scam on people. I mean, actually, I don't want to go too often on the deep end, but his whole family and the Chaudhry family, all you can look through their lives and see that kind of thing.
Yeah, because I mean, it's interesting. Apparently, Gutierrez came highly recommended because she had represented Bilal and Rabia's brother against criminal charges.
Yes, absolutely. Well, Bilal and Rabia's brother were actually called to the grand jury on Adnan's case, and she represented them in that procedure.
Oh, okay. I misunderstood what I was reading.
Yeah.
Thank you. I'm
Mhm.
so glad you're here. You're gonna help. You're gonna help
Okay.
keep me on the straight and narrow for this one.
Okay.
And please, I do want any misconceptions I've made with the material that's available or with my brief review for this episode. Please feel free to correct me when I'm wrong.
I will.
And
I
his
don't think I'll have very much to correct you on, but I'll definitely add if I have more insight or something, I'll pop up and do it.
perfect.
Mhm.
All right, so Syed's emotional, mental, and this is my lay opinion, he's misogynistic, which may be partially due to the culture he's been raised in.
Mhm.
He's controlling. He uses drugs and abuses drugs, or was using and abusing drugs. And he was also trying to live in two worlds. He was trying to live in the conservative world of his parents, but in the normal kid world of his peers.
Exactly. And I don't know how much we want to go into this, but there's the thing with Bilal Ahmed, who was his mentor at the mosque. And Bilal, of course, as you know, was caught molesting a 14-year-old boy in Baltimore that same year in
Mhm.
1999. And more recently, toward 2010 or 11, something like that, he was a dentist in the Washington area, and he was arrested and charged with molesting, using anesthesia on young males and molesting them, and he's in federal prison right now for that. So
Mhm.
I don't know. Nobody knows. I mean, nobody can say what happened, but obviously Bilal bought Adnan's phone. He had a picture of Adnan as well. He was the first one to visit Adnan in jail. So something was happening. So Adnan did have that you know, to deal with.
Potential that Adnan was potentially, although I don't see, I don't know that he would be a victim. I think he
Mhm.
would be able to keep Bilal at arm's length, but get what he
Mhm.
can get out of Bilal.
He may have. That's true, and it's possible. I mean,
That's the impression I get
he's
from him.
definitely a user. That's no doubt. There's no doubt about that.
And his victim was Hae Min Lee.
Mhm.
The crime occurred on January 13, 1999. Hae Min Lee was 18 years old. She moved to the United States with her mother and brother in around 1991 or 1992. She ended her brief relationship with Syed because she wanted a public relationship. Syed, a Muslim, had strict parents who would not accept Hae, a non Muslim, as a suitable relationship for their son. Statements about Syed's reaction to the breakup are inconsistent. Syed wrote "kill her" on a letter he received from Hae, which implied that he was not taking the breakup well. on the morning of
Actually, he wrote, "I'm going to kill."
I'm going to kill. Okay.
So it's even
All right.
worse.
That is, it's like I said, the negative information about Syed is so sometimes difficult to find because it's been so suppressed by the serial and Rabia Chaudhry, and
Exactly.
so it's very, very confusing at times getting the correct picture. On
And
the morning of January 13th, 1999, Syed gave his new cell phone to a drug dealer, Jay Wilds, and let Jay Wilds use his car. It was reported that Syed asked Hae for a ride home from school, although no witnesses reported seeing the two leave at 2 p.m. When Hae failed to pick up a young cousin at school that afternoon, her family became concerned and contacted police. Syed was contacted by police and claimed he had no knowledge of Hae's whereabouts. During the period between January 13, 1999, and the discovery of Hae's body in a shallow grave in Leakin Park on February 9th, 1999, Syed never tried to call Hae at home or work. On January 25th, 1999, Syed was questioned by police and couldn't tell them where he was or what he was doing on January 13th, 1999. Wilds initially denied any knowledge when first questioned, but soon broke the case. Wilds led police to Hae's car and provided them with an admission from Syed and eyewitness testimony regarding the burial of Hae's body. Syed's cell phone records and testimony from other witnesses corroborated some, if not all, of Wilds' statements. Wilds pled guilty to accessory after the fact and was sentenced to 5 years in prison. So now we start with the initial phase, which is the investigation to the pretrial phase for Syed. Of course,
let me go back. Did we
Sure.
mention that Jay actually he was the penalty was 5 years, and that was his sentence, um, but he actually had no jail time. It was only 2 years of probation
Okay. All
that he
right.
wound up with. Yeah.
Okay. Yeah, I'll correct that for any future. So he was sentenced to 5 years and it was suspended.
With all suspended but 2 years of probation.
Okay. Thank you. I am going to keep that, make sure I make a note of that.
Okay.
Because I didn't find any official documents on Jay's criminal charges, so I just went with what was being reported.
Okay.
So the investigation begins on at 5 p.m. on January 13th, 1999, when Hae's family reported her missing. She was last seen leaving school between 2 and 2:30 p.m. And of course, witnesses can be wildly inconsistent with their times. So she could have left as early as 2. It could have been 2:45. One witness could have seen her or thought they saw her at 2:15, but they really saw her at 2:30. So it's a lot is made about the witnesses' times and trying to, in the attempt to exonerate Syed. But in reality, those witnesses may have just been off on time.
That's the thing you have to remember about this case, because they were off on time and they were off on the dates too, because some of the things that the witnesses reported, we have now been able to establish actually occurred a week earlier. Like the game they were going to, that was actually, I think it was lacrosse, or no, it was a wrestling match, and they were going, and that actually happened a week earlier. And even the TV filming where they showed Hae, an interview with Hae, that was a week earlier. So, and then you have Inez saying she saw Hae drive out of the school parking lot around 2:30. You have someone else saying that they talked to her 2:40, and you have Debbie Warren saying that she talked to Hae by the gym at 3:00. So it's all over the place.
Right. And but I think the important thing to note is that the times that are material are corroborated by phone records.
Yeah.
And the times that the state has given for the crime that's based on corroboration with phone records.
The state had a theory of the crime that Hae was dead by 2:36, and that was based on a 2:36 call that they thought was the "come and get me" call to Jay Wiles, but Jay never said that, and so it. Most people don't think that she was dead by 2:36. They believe that that assumption by the state was probably wrong, but the courts have found that that doesn't matter because she could have been killed anytime after 2:30 and before the burial time at around 7:30.
Right. Okay. So, Syed had an initial interview on January 13th, 1999 by phone with Officer Adcock. He told Adcock Hae got tired of waiting for him that afternoon and left without him. So essentially he's saying, yeah, I was supposed to ride with her, but I didn't ride with her because she got tired and abandoned me. And then in a second phone interview on January 25th with Detective O'Shea, Adnan says that he was at track practice on January 13th and he did not see Hae leave and that he had no idea where Hae was. Then in a subsequent interview with O'Shea on February 1st, he told O'Shea that he was not waiting for a ride home from Hae on January 13th because he had his own car, even though he'd let Jay use the car, which he didn't disclose.
Exactly.
But he's trying to say, oh no, Adcock's lying. I didn't tell him that because I have my own car.
Right.
So, he must have learned well at Robb Chadwick's knee.
Must have.
and Robria, if you ever end up listening, sue me. Because I will love discovery with you. Oh my God,
exactly.
we will have so much fun, girl.
Absolutely. She doesn't, she claims to be a lawyer, but she's not really. She did some immigration work, but that's about it.
Yeah. So, all right. Well, I've never claimed to be a lawyer. I'm just a paralegal.
Well, okay.
But I think 40 years experience kind of helps.
I think so.
So, and it's important to note there were multiple phone interviews with Syed, which is based on a February 14th report authored by Detective O'Shea. There was a face-to-face interview arranged to take place on February 10th, 1999. Did that happen? That
No,
would have been the day after
that was the
Hae's
day
body
after
was
Hae's
found.
body was found, so that didn't happen.
And of course, as Hae's body was found in a shallow grave in Leakin Park in Baltimore. Now, interestingly, from what I understood, somebody actually placed rocks on her body to prevent animals from moving it, or that was a theory.
I've heard that. I'm not sure. It's not widely reported, but I've heard that mostly they buried her in a depression. I mean, there was already a natural depression there, and they dug a little bit and they put her in that. They put like what was around, like the earth and sticks, maybe, and that's mostly to bury her. But I don't know about how much what it was for animals. But I have read that.
Okay. And then also I've read a lot about how this site was a really long way for somebody who's looking for a place to take a leak.
Yeah, it's quite a ways. It is.
Well, from what I saw, it's right off the road. There are like two concrete barriers and there's a log and then Hae's body. That was what I understood from the pictures. Hae's body was there. Right next to the roadway.
Yeah, there were those Jersey walls, and then you had to walk back about 160, 180 feet.
Oh, okay.
Or maybe yards, either feet. But it was way back near they have a little river back there, a little called Dead Run, crazily enough. But her body was way back there.
So, and I just have to comment. So they were too lazy to actually dig. Yeah. They found a partial hole. And they dug for a couple minutes, and then they said, good enough, probably because they were both high.
Yeah, Jay said in his interviews that it was about 6 inches that they dug, and that was it.
Yeah. So, all right. So, then on February 12th, 1999, two anonymous callers tell police to look at Syed. Now, interestingly enough, I've seen that one of those callers is believed to have been associated somehow with Syed's family. But it sounded in one of the calls, it sounded like a a, a, a Korean accent or an
Well,
individual whose first language is
mhm.
and a Korean, uh, not someone that's from the South Asian, Indian, Pakistan areas.
Well, I think the texter's name was Massey, who received both calls, and both calls were actually from the same person, but they
Okay.
involved a different person too. But Massey said that he had an Asian accent, and he didn't really explain it ever until the HBO production. I think he said it was. I can't remember. I think he said it was South Asian. But anyway, he did say it was an Asian accent. So the guy calls him and tells him to look at the boyfriend. Then he hangs up. He calls back and says, and you also ought to ask Yasser Ali, Adnan's friend, all about this.
Okay. All right. So there goes another one of my little bubbles burst. Just kidding. Because I thought it was somebody in Hae's family
Well,
who
people do speculate about that. I mean, it could have been, but who would have known Yasser Ali and Hayes family?
that's true.
I mean,
That's true.
so it had to be somebody from you would think it had to be somebody from the mosque because Hayes' brother, he wouldn't know. He did know Adnan. I mean, when they tell you that Adnan was a secret, Adnan was not a secret.
Mhm.
He called Hayes' house all the time. He went into Hayes' mother's bodega all the time, even without Hay. So Adnan was not a secret. So, but I don't think they would know his friends.
Mhm. Okay. All right. So then on February 26, 1999, there is a fourth interview where Syed says he doesn't know what he did on the day Hay disappeared,
Mhm.
which to me is the most ridiculous thing I've ever heard because
Mhm.
you're talking about 13 days. Um, I could understand 5 years later, 10 years later, but 13 days, you don't know what you did? You don't
On
know
a
where
day
you were?
on a day the police called you and told you your girlfriend was missing.
Correct.
It's unbelievable. It should have everything about that day should have fallen into a complete memory
Right.
at that point.
Right. Totally agree. I find
Mhm.
it to be absolutely, and anyone who thinks, well, he didn't do anything wrong, that's normal, is just like I could tell you what I did where I went on Friday.
Yeah,
I'm sure you
sure.
could tell me, last Sunday, I could tell you what I did where I went,
Of
which was
course.
nowhere. Um, anyway, so then on February 27th, Jay Wild is interviewed. Now, can you debunk something for me?
Okay.
Um, were there prior interviews of Jay Wild, formal interviews of Jay Wild prior to February 27th?
No, that was his first interview. Now, the defense talked to Jay's manager at the porn store. Her name was, I believe it was Sis. And she told them that Jay had to leave one day. Something about the police. This was something in February.
Mhm.
Uh, but there's no record of that. And she couldn't remember what date. She didn't even know what date Jay started at the store. Sis is not a reliable witness. So, but that's where they go. That's where they got that from. But the truth is, the police talked to Jennifer Pusateri on the 26th at her home, and she said, I'll come in soon and talk to you. And she did go the next day with her mother and her attorney, and that's when she told them everything Jay had told her.
Okay,
And
now
then,
I
yeah,
had missed that. I missed that in my notes
okay.
because that was what broke the case, not Jay, but Jennifer.
Jen told everything, and that's why it's such a solid case because Jen, people like to give her a hard time, and she hasn't had the best life in the world, but I can't find a single time where she's lied.
Mhm.
So
Right.
she is the one that told the police. So if for the police to have to tell Jay this story, I mean, I don't. She's the one that told all these things, and Jay confirmed most of it. But they don't agree about every little thing, which is good because if they did, you'd think it was memorized.
Correct.
Hmm.
Correct. All right. So yeah, I totally missed Jen's interview, which is what broke the case.
Hmm.
And that was on February 26th.
February 26th, yes.
And
I may have
then
said January, but it was February.
yeah. So and then Hayes' vehicle is located on February 28th. Now, that was Jay led police to the car, which was parked on a grass lot behind some row houses on Edgewood Avenue.
That's right.
Now, according to another podcaster, Bob Ruff, who's as full of crap as Rabia, he has listened to Jay's interviews, and he's determined by tapping that that's how police fed Jay information. What do you have to say about that?
Well, I'll tell you, it was actually
Theory.
Susan Simpson of Undisclosed came up with that idea, and Bob's ran with it like he does with
Okay.
everything. But I'll tell you, and it's a strange thing. It's an old tape recorder, and I'm sure it makes a lot of sounds. But
Mhm.
there's an interesting thing about this. If you look at The Wire, season 1, episode 13, there's a segment where they have a witness and they're interviewing him, and they're actually tapping on a window to try to help him remember things.
Okay.
And I think that's where she got the idea, but I can't prove that.
Okay.
But the taps were just noises. I mean, they.
Yeah. Yeah. Yeah, I used to do we had a weird dictation machine at one of the offices I worked at, and there was all kinds of background noise.
Oh yeah, definitely.
That was you got used to it after a while, but initially it made it really difficult to hear what was being said
Hmm.
because it would kind of overwhelm the dictation. All right, so then I'm going to go through a thumbnail sketch of the evidence against Syed as of February 28th, 1999. Feel free to add to, correct any mistakes I've made.
Okay.
We've got the fact that Syed asked Hae for a ride after school on January 13th, 1999. He gave his car and cell phone to Jay Wilds at lunch on January 13th, 1999. Jay Wilds had Syed's car and cell phone. He had a call from Syed to meet at Best Buy. He saw Hae's body in the trunk of her car. He went with Syed to leave Hae's car at the I-70 Park and Ride. He returned to Hae's car with Syed at the I-70 Park and Ride, and then drove Syed's car to Leakin Park while Syed was driving Hae's car. He helped bury Hae's body. He received a call. He talked about a call received by Syed while he was at Leakin Park. He went with Syed to abandon Hae's car on Edgewood Avenue. He disposed of evidence after the burial with Jen. Jen's statements corroborate some of Jay's statements.
All of the
Nisha and
important
Christina
ones.
also corroborate some of Jay's information.
Hmm.
The phone records corroborate Jay's statements about the call while they were in Leakin Park. Syed did not try to contact Hae from January 13th to February 9th. The I'm going to kill her on the note from Hae. His partial palm print on the back of a map book. There was also a fingerprint on paper
Yeah,
wrapping a
I was going to
rose.
interject that in there. Adnan had been known to give Hay a rose from time to time, and this car she had that where she was killed, she'd only had it a couple of months. But anyway, the map book was normally kept in the driver's pocket seat where she could just take it out and look up where she wanted to go. Well, when they found the car, that map book was lying in the back seat with the page that shows Leakin Park torn out, but on top of that was some floral paper with what was left of a rose wrapped in it. And guess whose fingerprint was on the floral paper? And guess who's not?
Jay.
Adnan's fingerprint was on the floral paper, and Hayes was not. So
Oh, and
my
Hayes
theory,
was not. Okay.
no. So my theory is he presented the rose to her to try to, make up with her or whatever, and she refused it, and he just tossed it in the back seat, and that's probably what precipitated what happened.
Yes. Adnan Syed was arrested on February 28, 1999. There was a bail review hearing on March 1st, and no bail was ordered by Judge John Hargrove. Then we move into the pretrial stage. The venue was the Circuit Court for Baltimore City. Honorable David B. Mitchell, and then the Honorable Judge Wanda Keys Heard was the judge for Adnan Syed's second trial.
Now,
His counsel.
the first trial was actually not David Mitchell. I think that was, I don't know who he was, but the first trial was, and he was on a Nancy Grace show. Quarles, Judge Quarles
Okay.
was the judge for Adnan's first trial, and then Wanda Heard was the second trial. I forget who David Mitchell. He may have been at one of the bond hearings, or he may have been someone else. I have read the name before, but
yeah, he issued the order on the bond.
Yeah, that's right.
On the writ of habeas corpus for bond.
Right, exactly.
So, but as you're correcting me, I am adding to my notes here so that I can add it for future reference.
Okay.
Now,
I think it was William Quarles that was the judge on the first trial.
What's that name?
I think his name is William Quarles. Let me look it up real quick.
Okay, perfect.
He was on the Nancy Grace segment. He was very, very, very good. He said he believed Jay did it, and then of course Judge Heard had already posted on Facebook that she knew he was guilty.
Counsel, Adnan Syed's counsel at the time for the pretrial was Christopher Scott Flawn and Douglas L. Colbert. He filed a petition for writ of habeas corpus on March 16, 1999, challenging his no bail status and seeking bond. There was a hearing on March 31st, 1999. And then a memorandum order was issued on April 1st, denying his request for bail. There's a lot of controversy about that because there was an allegation that he was a flight risk because of his ties to Pakistan.
Yes.
Which I think is not an unreasonable.
I don't think it's unreasonable, especially since I found new passport pictures in his room when they arrested him.
Okay. Yeah, that would be. So, and the fact that Pakistan would not have extradited him if he'd fled there.
Right.
So, and I don't think there's anything wrong with the prosecutor raising that as a potential flight risk.
Right, especially since nobody charged with first-degree murder got bailed in. Everybody charged with first-degree murder was remanded.
Yeah, that too. So, on April 13th, 1999, an indictment was handed up charging Syed with first-degree murder, second-degree murder, robbery, kidnapping, and false imprisonment. And on September 7th, 1999, Jay Wilds entered a guilty plea to accessory after the fact to the murder of Hae Min Lee and was sentenced to 5 years with 2 years suspended, but 2 years probation.
Right, exactly.
All right. So then we move to the trial phase. The counsel for the state was Kevin Urich and Kathleen Murphy. By this time, the quote community had decided to hire Maria Cristina Gutierrez, who died on January 30th, 2004, and she was retained counsel. She was not a public defender. She was being paid by private individuals. Syed's first trial began on December 9th, 1999, and ended on December 15th, 1999, when the judge called Gutierrez a liar and members of the jury overheard that.
Mhm.
And one of them, bless their little heart, said, "Oh, you said that the attorney's a liar. Are we going to start all over? Is she going to be removed?"
Yep, that's what happened.
Now, do you know what was the issue that I know he was kind of, let's say, annoyed.
Yeah. What happened was the state introduced the cell phone records or something to do with the cell phone records into evidence. And she said, wait, I've never seen this. And to make a long story short, there was a bench discussion. And Judge Quarles said, ma'am, Ms. Gutierrez, I know you've seen them. You stipulated to it before, and that I don't think he actually came out and said you're a liar. I think he said, I'm not going to let you lie to this court. I think that's what he said. And a
Okay.
juror or overheard that over the white noise and said, you've told us that Ms. Gutierrez is a liar. Will she be removed?
Okay. Yeah. So but she had challenged them
Hmm.
in the pretrial, during the pretrial proceedings. So
No, it
she
was
knew about him and she had him.
right. She did. And of course, it is a really long story, but I mean, she was objecting to saying she had seen some of them, but not this one. And, that sort of thing. So, but that was the short version of it that I gave you.
So, so kind of like what they're doing, what they're basically doing now is we didn't see that.
Mm-mm. Well, it was an open court
Yeah.
because the jurors heard it.
Yeah. But no, I mean they're doing the same thing. They're claiming
Mhm.
they didn't see a note. They're claiming that the
Oh,
defense didn't
yes.
have things, which is a
Right, right.
common, which is such a common um, BS tactic. Anyway, but um, we'll get into that later.
Okay.
The second trial began January 7th, 2000, and was concluded on February 25th, 2000. And Syed was convicted of first-degree murder, robbery, kidnapping, and false imprisonment. A judgment of acquittal was entered on one count of robbery accessory after the fact, and then two additional robbery counts were null prost, and that was apparently on one of the indictments.
Hmm.
But the records aren't. I can't find the indictments, the physical copies, so I have all their numbers, but I don't have what they were.
Right, right.
So, and what each count, et cetera, et cetera. So, that was a little frustrating for me. Post verdict motions, a motion to replace Gutierrez was filed and granted, and the sentencing was reset. And then a motion to hold sentencing in abeyance was denied. Counsel for sentencing was Charles Dorsey. That took place on July 28, 2000, and Adnan was sentenced to life plus 30 years. Now, this was after a sentencing hearing where the judge made a discretionary determination. It wasn't a minimum sentence situation. Um, do you recall whether it was
You
like
mean
a full
about
hearing where the judge made a discretionary determination?
about the which part of it? I know what she sentenced him to
The life
life
the life
on the
sentence.
on the murder and
Yeah.
30 years on the kidnapping.
Yeah. But
And
I'm trying to determine if it was a minimum sentence and she had no discretion, he was a juvenile, and that would lead to that sentence being
the minimum,
challengeable
yeah, the
later
minimum
on.
for first degree murder was life in prison.
Okay.
If
So
they
it
had convicted
was
him of second degree murder, it would have been 30 years.
okay, so it was a mandatory minimum sentence.
Hmm.
Okay. But I think the judge still had discretion.
Well, yeah, he was not sentenced to life without parole. So he could have been paroled on murder at 15 years. In fact, she said that during the sentencing and then he would have had to serve the 30-year sentence for kidnapping, which have also been 15 years, according to
Okay.
guidelines. So he, he still is not really eligible for parole to this day, unless you factor in good behavior and all that. And I'm not sure what they give for good behavior in Maryland, but
Okay. And so post-sentencing motion on August 2nd, 2000, a motion to modify sentence was denied. He went to direct appeal, which was he was represented by Warren Brown and Nancy Forster. His conviction and sentence were affirmed on March 19th, 2003. In an unreported opinion that is very, very long, he filed a writ with the Maryland Court of Appeals, which was then called.
He filed that himself.
Yeah.
On
June.
That was per se. Yeah, he didn't have a lawyer for that one.
And that was on. He filed that on June 25th, or on June 25th. It was denied. Then his conviction and sentence became final on June 25th, 2003, because no writ was filed at the U.S. Supreme Court.
No, he didn't file to U.S. Supreme Court. He filed for cert with the Maryland Court of Appeals. It's now the Supreme Court. But the Maryland Court, and they didn't even hear the case. I mean, they just denied it.
Yeah. And then in state post-conviction, he was represented by C. Justin Brown. That was again in the Circuit Court for Baltimore City, Honorable Martin P. Welch. An opinion was issued denying relief on December 30th, 2013. A notice of appeal was filed on January 27, 2014. A motion for leave to supplement was filed on 1/20/2015, and that motion was granted on February 6, 2015. So then the case went back to the Circuit Court for hearing on May 18, 2015. Again, the reopened state post-conviction was in the Circuit Court for Baltimore City. There was a hearing from February 3rd to February 9th, 2016 before Judge Welch. He issued an opinion on June 30th, 2016, and he granted relief and vacated Syed's conviction and ordered a new trial.
Right. Let me say just a little bit about that.
Sure.
Judge Welch, of course, in the initial post-conviction relief, they had cited Asia McClain as a witness that saw Adnan in the library about 2:30 on the 13th, but they couldn't get her to court. She refused to cooperate. So Judge Welch denied, that he denied that appeal. Now, Serial comes along in 2014. Asia decides, oh man, here's an opportunity for me. So she gets on board again. So when it went back to Judge Welch in 2016, he couldn't quite bring himself to give Adnan a new trial on Asia. So he said, well, Ms. Gutierrez should have contacted Asia, but she wouldn't have made any difference because, there was plenty of time. 2:30 is 20 minutes out of a bunch of hours that he could have killed Hae. So, but he did. What Judge Welch did, he filed relief on some cell phone evidence. Actually, I think the Serial team found it, but Susan Simpson introduced this fax disclaimer that said incoming calls were not reliable for location, which is just a billing thing, but they ran with it. And Judge Welch decided, well, this is something I'm going to overturn the conviction on. But the strangest thing was he admitted, he said that the reason why he's doing that because it was too late to bring this into the case. They should have acted on this a long time before. But he said that Adnan had not graduated high school, so he didn't feel like he had the opportunity to defend himself, which was the weirdest thing. And this was after Judge Welch wrote that to let everybody know that Serial had no role in his decision. So what does that tell you? I mean, Serial definitely had a role in his decision.
Yeah. And that was always the thing that mystified me, was that disclaimer is, if that were an issue, it should have been raised at trial.
It should have been. It should, or at least in the appeal or something, or a long time before it was. I mean, you're talking about
Yeah.
16 years.
Yeah.
And of course, and cell phones were different back then, and we don't know exactly what it means. I think it may have something to do with roaming charges, or it may have something to do with voicemails that don't connect. But it definitely
Hmm.
doesn't have anything to do with connected calls. And both of those Leakin Park calls were connected. They were both answered.
Right. Exactly. And that was another thing too, is that at the as I recall, at the hearings, nobody from AT&T came on and said, "Oh yeah, these Leakin Park calls, we can't believe them because these are the reasons."
Right. Well, they had
That was
an
nobody from
FBI.
AT&T, and I think
No.
they did have the state's expert at the trial
Yeah.
backpedal on his testimony.
It was Chad Fitzgerald. He was an FBI expert. He actually had a lot to do with the Boston Marathon bombings.
Mhm.
And he said, and he tried to explain it. It's like when you talk to a doctor, you don't always understand what they're saying. He tried to explain it though, like if your phone was turned off and you immediately turned it back on at a place you had not been, that it might show this other place where you had been previously or something. That's the gist of it. But the judge didn't understand it. He didn't understand cell phones. He didn't understand tech at all. So, he didn't like that witness.
Mhm. But that Abe guy.
Abe Waranowitz, he was the witness at the trial. He was the AT&T engineer. And
Right.
at the post-conviction relief, they brought in Chad Fitzgerald, who was an expert on cell phones
Okay. But they
with the
got an
FBI.
affidavit from him, from Abe, backpedaling on his trial testimony, as
Well,
I
well,
recall.
what Abe said, and I don't want to go into all of his issues, but he said basically that he didn't know what he would have done if he'd seen that he didn't know if he could stand by what he said because he hadn't seen it. He didn't know what it was, and he didn't,
Okay.
so that he never said that he was wrong. He just said, I don't know what I would have done.
Okay. Yeah. But it's claiming I didn't know.
Yeah.
Okay. That I didn't it wasn't given. Because I think they tried to allege Brady violations on that
Oh yeah.
AT&T cover sheet too.
Oh, that was so funny. Susan Simpson, yeah, they tried to, Jason Brown tried to allege Brady violations, and then they got part of the defense file and looked at it, and well, that's another story. The defense file, of course, which should be protected information, but Rabia had been doling it out piecemeal for people online. So they finally ruled that the defense file was no longer protected. So the state actually filed a subpoena for it. So they had it. They had the defense
Mhm.
file, and that page was in the defense file.
Yeah. But it wasn't until the state had it that they that they were able to say, "Here, look, the page was there." They were
Right.
claiming they had it, and they were claiming it didn't exist.
Exactly.
Yeah. So, no, and this is the thing. I think that in any case, the Brady claims should not succeed unless the entire defense file is produced and the material is truly not contained. Saying,
Right.
"Oh, I don't remember seeing it," or "I didn't get it when I did," is not sufficient for me.
Those are good standards that you brought up, but this case will never be able to pass those standards because Rabia took that defense file with her for 10 to 15 years in the trunk of her car. It was wet.
Mhm.
It was had been rained on. Um,
Mhm.
she had gone through it, I'm sure, and taken things out.
Yeah. So,
So,
all right. Well, moving on, we have the post-conviction appeal. That was in the Court of Special Appeals, which is now the Appellate Court of Maryland. A request for leave to appeal was filed by both the state and Syed. Leave was granted on January 18th, 2017. An opinion affirming in part, denying in part, was issued on March 29th, 2018. And the court found that trial counsel's failure to contact alibi witness was deficient. Cell phone claim was waived because it could have been raised in the additional post-conviction claim. So they basically reinstated Adnan Syed's conviction for the first time.
mhm.
A writ was filed to the Court of Appeals, which is now the Maryland Supreme Court, on July 12th, 2018. oral argument was held on November 29th, 2018. Decision was rendered on March 8th, 2019, and I guess I have reversed in case remanded.
It was
They
just,
held that trial
yeah, it was
counsel's
reversed.
performance.
It was just reversed. That was well, he
Trial
later
the
filed to the Supreme Court, but yeah, okay.
Yeah, that was reversing and remanding. I'm not quite sure.
I'm not
They
sure.
held that trial
I don't
counsel's
think it was remanded. I think it was just reversed because
okay.
they wouldn't have anybody to send it back to, I don't think.
Yeah. Trial counsel's performance was deficient, but Syed failed to demonstrate prejudice or that McLean's testimony would have changed the outcome of the proceedings against him. The cell phone tower location claims were waived because they could have been raised in the first ineffective assistance of counsel petition. So that would actually be affirming the Court of Appeal, the appellate court.
Well, on the Court of Special Appeals, which was the intermediary court at that time, they actually they granted a new trial based fully on Asia McLean. They denied the cell phone
Okay.
evidence. They say they did grant they affirmed Judge Welch, but in the opposite way. They denied the cell phone, but they did say that Asia McLean was big enough that she might have made a difference. But when it got to the Supreme Court, well, it's now the Supreme Court, they said, okay, they should have contacted her, but she wouldn't have made a difference.
Yeah. All right. Syed filed a motion for reconsideration on April 8th, 2019, which was denied on April 19th. An application seeking additional time to file a petition for writ of certiorari to the U.S. Supreme Court was filed on June 17th, and that was granted on the 18th. Syed filed a writ to the U.S. Supreme Court on August 19th, 2019. Pardon me, and that was denied on November 25th, 2019.
Mm-hmm.
Then there was also in 2018, there was an order granting DNA testing of crime scene evidence. The results were across the board inconclusive. Fingernail clippings yielded a single source female DNA profile consistent with Hae, with one indeterminate minor allele detected in the left fingernail clippings. Swabs from a bottle cap, long wire, and condom wrapper yielded inconclusive DNA results. Blood on the back of Hae's shirt yielded a single source female profile consistent with Hae. Swabs from a short wire yielded a single source female DNA profile inconsistent with Hae. And other evidence tested yielded no DNA results. And then in 2019, the Maryland legislature passed a law to allow convictions obtained based on testimony from the Baltimore City Police Department's corrupt gun trace task force to be vacated. A joint petition for DNA testing was filed on March 10th, 2022, and that was a joint request between the state and Syed, because by this time, Marilyn Mosby was now the state's attorney, which is what the district attorney is called in Maryland. She had gotten into bed with Syed's defense and was trying to get some positive press because during the COVID-19 pandemic, she lied and got a loan and claimed she wasn't working and committed fraud. And so she needed something, good public PR, maybe hoping to make friends with people in jail, because when she goes to prison, she can say, but I got Adnan Syed released.
Right. Exactly.
Speculating, but
Yeah.
And on March 14th, 2022, an order granting the joint DNA petition was entered. The 2022 results have not been released to the public. The state's attorney's office claims Syed was excluded by DNA testing, but the only detail they mention is that shoes found in Hae's car yielded a mixture of DNA from 4 people. Now, have you ever found anything documenting the results of that 2022 DNA testing?
I haven't seen the documentation. I heard that there was no DNA on any of the other items, and that the only thing was the shoes. Her black high heel shoes were found in the back floor, the back seat floor area behind the passenger seat, and that they contained DNA from four individuals, unnamed, unknown individuals. Which to me, I mean, what do you expect? I mean, she's walking on things.
Hmm.
So, but that's no, I've only heard about the shoes. I mean, actually, I've heard that there was no other identifiable DNA, but I've only seen things that are relating to the shoes.
So essentially, it was inconclusive.
Right.
And
Except
there's
for,
and
no,
there's no evidence to date that either of the alternative suspects are
mm-mm.
included in that DNA.
No, they never said that. I mean, I don't know what DNA would null process case based on no DNA on the soles of people's shoes. That's just crazy to me, don't you
Hmm.
think?
Hmm. Definitely. All right. So now we're at the vacatur motion. The venue was the Circuit Court of Baltimore City. Honorable Melissa M. Finn, and she is a defense-oriented judge, if ever there was one.
Definitely, definitely.
Syed by this time is represented by Erica Suter, who is a director at an Innocence Project clinic at the University of Baltimore. Becky Feldman, a former defense attorney, is now a prosecutor with the state's attorney's office, which is, it usually goes the other way.
Hmm.
Um, so, but I think Mosby, being a pro-defense herself, brought in these defense people to try to take apart the
Right.
prior state's attorney's work. And some of it, yes, some of it is warranted because the gun trace task force was a bunch of
That was
thieving,
pretty corrupt.
lying,
Yeah, that was bad.
corrupt individuals. But you know what? If they had been doing anything else and not been cops, they still would have been thieving and corrupt and liars.
Exactly. I do want to say one thing, and I don't think a lot of people realize this. I'm not, you may realize it, I don't know. But uh, Marilyn Mosby, Souter, the judge, Melissa Finn, and Rebecca Feldman, they had all worked in the office, that the public defender's office. They
Yeah,
all came. They all
yeah,
came from that office. Yeah.
yeah. So yeah. And then Young Lee was represented by Stephen J. Kelly
Hmm.
and also Ari Rubin, although Mr. Kelly took the lead during the initial proceedings.
Hmm.
And basically, this starts with on September 12th, 2022, Becky Feldman sends a draft of a proposed motion to vacate to Hae's brother Young Lee via email, stating that it would be filed on September 13th, 2022. Young Lee responds on September 13th, and his response is heartbreaking, especially knowing how things turned out. He said, "To be clear, as a family, we disagree with your course of action and stand against the motion to vacate judgment. We believe that there's overwhelming evidence and the court convicted the right person. I hope you understand the emotional turbulence this trial is causing us. It seems there is never an end to it, but we understand your position as an attorney to do due diligence and cover all possibilities." On September 14th, Feldman responds and she says, "I very much understand your family's position. I am so sorry for the pain this case is causing you." Lying sack of. Anyway, the motion to vacate was then filed on September 14th, 2022 by the state's attorney's office to vacate Syed's conviction pursuant to Maryland Code of Maryland Code of Procedure annotated section 8-301.1. Now, the allegations are the most ridiculous crock of crap I ever read. And in my opinion, it was authored with the intent to poison the media, which
Right.
doesn't even need any help. They're going to
Exactly.
believe what you're telling them anyway.
That's right.
They allege a year-long joint investigation has uncovered Brady violations and new information about 2 alternate suspects who they refuse to name
Hmm.
and who they refuse to provide any detail as to what makes these people viable suspects. They talk about the DNA testing status, which at the time was not even completed. The 2018 results were inconclusive, and the 2022 yielded no useful typing obtained or male DNA too minimal to produce results. Only female DNA was recovered from other evidence. That's what they said in the motion. And then later they come up with this bullshit about a pair of shoes.
Right.
They
Exactly.
provide their facts of the case, which are like, it's like Erica Suda wrote them for them. They provide a procedural history. They provide a legal requirement regarding the hearing being requested. And then they talk about the 21-22 investigation and the new information suggesting motive and or propensity of 2 alternate suspects known at the time of the investigation. They allege a Brady violation if 1 suspect threatened to kill Hae, according to notes regarding 2 witness statements in police files, proving a threat and or plausible motive for the alternate suspect. This one is Bilal.
Bilal Ahmed, yes, that was his wife that called Kevin Urich
Mm-hmm.
and told them that she was afraid. She was divorcing Bilal at that time because she found out that he was, that he liked boys, and so she was divorcing him. And for some reason, she called Kevin Urich and told him she was afraid, and she had heard this conversation, which might want to wait on this, but that whole conversation, if you read the whole letter, there's a kind of a unclear sentence where he said he was going to kill her, but if you break down the grammar, it would be Adnan saying that.
Mm-hmm.
But then there was more in that letter that all this conversation. For this conversation, Adnan was present, Bilal was present, she was present. There was information about Jay, there was information about Christina, and Bilal's wife was a medical student or a doctor, one or the other. And Adnan was asking her, Bilal and Adnan was asking her, how could they determine the time? Could people determine the time of death?
Mm-hmm.
So that's
Right.
not exculpatory.
I know. I know. We'll talk about this a little later in the appeal, but they filed stuff that they thought helped them that did not help them at all.
Exactly.
But
They
they
said, well, if
tell
you don't
people
think
it
that,
helps them, and people are just automatically vomiting back. Oh,
right.
it's exculpatory.
Yeah, and they also said this shows you how amateur it was. They said, well, now if you don't think this is Brady evidence, if you think it was turned over, well, it would be ineffective assistance of counsel because the lawyer didn't use it. They said that in the motion.
Yeah, but it's like it's hearsay.
Right. Oh, the whole thing. They couldn't use that because Bilal, it would be, unless Bilal would testify. I guess Bilal could
Mm-hmm.
testify to it. And of course, I'd like to, but he's not going to. So they can't tell
Yeah,
unless Adnan confessed to the wife. Now, if Adnan did confess to the wife, she could testify, but she wouldn't do it anyway. So, so it was
right,
total hearsay, but basically that's what it would have amounted to.
right. All right, so that was A.
Mhm.
B. Hayes' car was located behind the house of a family member of 1 suspect, making 300 Edgewood Avenue a location known to the suspect. A relative owned the house for many years, and the relative lived there in 1999. This
Do you
information
want to
was
know?
uncovered
You want to know who
in
that was?
2022. Yes, that's Mr. S.
That's Alonzo Sellers'
Uh-huh.
sister's baby daddy.
Okay. Yeah. Okay. Yeah.
That's who that was.
Yeah. I'm calling bullshit on it.
I guess.
I mean,
I don't know. I don't know for
let's
sure, but
hope.
I don't know if Alonzo knew the baby daddy or not. You don't know if
Yeah.
his sister. Yeah.
Let's hope that Ivan Bates. Well, there's no connection between Sellers and Hae.
No, they can't. There's no way.
I mean, I
Mm-mm.
think they had one tenuous connection about him working near the school or knowing somebody who worked at the school or
Well,
something.
there's this silly stuff. His sister-in-law taught school there,
Uh huh.
He works for Coppin College, and at the time, the director there was the son or somehow connected to the mosque that Adnan went to. But there was no close enough connection.
Yeah. No direct, and there's no direct
Mm-mm.
connection with Hae.
Right.
And then also didn't they wasn't he also looked at as a suspect during the
Yes.
original trial, and he
It was
was
the original. Yeah.
working
Go ahead.
on January 13th, and it
It's
was
even it's better than that. He was
'cause
working on January 13th, but he was also interviewed by the police on that day at his place of work for some stolen equipment from the college.
uh-huh. Okay, yeah. So, because he knew what he was doing that day.
Exactly.
And if he didn't, there was a police report that would refresh his memory.
Hmm.
Okay, C. One suspect attacked a woman in a car and was convicted. This occurred after the trial. So, okay,
I don't know who that was. I assume it was Mr. S. If it was Bilal, I mean, he might
I
have
mean,
texted
Bilal
somebody, but
didn't like girls,
he
so
wasn't sexually interested in that woman. It may have been Mr. S, but Mr. S has no record for any kind of violence. Streaking, but
yeah.
no. As far as I know, no violence. So I don't really know
So
what
we
that
don't even know
is.
who that might be.
I really don't. Mm-mm.
Okay, and they wouldn't name it, claiming integrity of their investigation.
Mm-hmm.
Okay, one suspect engaged in serial rape and sexual assault and was convicted. This occurred after trial. This was Bilal, and the victims were
Hello.
boys
Right. Exactly.
and male.
Mm-hmm.
One suspect engaged in violence against women known to him and threatened to kill the victim. This information was known to the state because the events occurred before the trial. Again, that doesn't really, it can be Bilal.
Well, that's that note. That one spec was improperly.
Okay.
Once engaged in violence. Let's see.
No,
And,
violence against women.
and threatened to kill the victim. That's that. Yeah. Well, I guess that's Bilal. That's confusing. Threatened to kill the victim. That would be that note
Yeah.
where this. And they're saying the information was known to the state. Well, Kevin Urick did take the call,
But there's
but
no evidence that Bilal had a history of violence against. I mean, I think probably a lot of Pakistani men could be accused of a
right.
history of violence against women because that's the culture.
Yeah, it's possible his wife had filed domestic violence charges against him. I
Okay,
wouldn't doubt that. That's probably what that's talking about.
that may have been. All right, so I'll cross that one out
Okay.
as unknown. One
Okay.
suspect was improperly cleared after failing a polygraph test and being improperly administered a second test meant to deconfirm the deceptive result in the first test. That's Mr. S, but that's
Mr.
bullshit.
S.
That's not a valid ground for a motion to vacate.
Right. Mr. S was given his first polygraph test. I believe he failed it or it was inconclusive, one or the other. But it turned out he was late for an appointment for a real estate with his wife to view some real estate. So the polygrapher said, "Well, that's probably the reason we got these results. So we'll give him another one," which they did, and he passed it.
Yeah.
Um,
But that's not a proper grounds for a motion to vacate. It's not
mm-mm.
new evidence
Right.
because
Exactly.
it's based on a polygraph test and is basically Becky Feldman's opinion about the veracity of the polygraph test
Hmm.
or the polygraph examination. But it's not a valid grounds. It's not new evidence.
Right.
They claim the trial evidence is no longer reliable based on Brady violations alone. The state cannot rely on the cell tower evidence based on post-conviction court's findings. That's not true because that post-conviction court's findings were reversed.
Hmm.
And so the cell phone tower evidence, there is no legal basis to challenge it. And again, it's not new evidence. It's bullshit reason to say we don't trust the results of the original trial.
Many cell phone experts have been contacted and consulted over this, and the vast majority of them, I don't have a number, but the vast majority said there's no way that disclaimer had anything to do with the actual location of an incoming call that was answered. They have said, well, we don't really know what it meant, but it probably was something to do with billing, because that
Right.
was actually a billing record. It was not a record. It wasn't intended to show who somebody was.
Right. But there was a separate cell tower data examination.
I'm not sure what you mean. There was this one big form or inf- thing that said subscriber information.
Uh-huh.
Well, when they subpoenaed Adnan's cell records, they got this big form, and the cell phone numbers had been redacted. They had to get a special subpoena to get a portion of it where the cell phone numbers were not redacted.
Okay.
And they took just a piece of that report and introduced it to the court, but it was the same report, really.
Mm-hmm.
And the judge at the PCR, the post-conviction relief hearing, he didn't really understand that. He thought there was two separate reports, but it was just a part of the big report.
Mm-hmm. Okay. All right. And then B, Christina Vincent's corroboration of Wilds was incorrect based on a winter schedule presented to her and her recantation in a documentary. Again, that's not new evidence. That is an out-of-court statement. There's no affidavit from Christina Vincent. There's no testimony from Christina Vincent under oath, subject to cross-examination, that actually recants anything. And even if Christina's corroboration is incorrect, there's Jen, there's Nisha,
Yeah.
there were 2 or 3 other people.
But Christy doesn't. She's correct about that, because they didn't base that. And you'll hear people say all the time, "Well, they didn't. They couldn't say what day it was or what the date was." Well, you know what they could say? They could say that it was Stephanie's birthday. And
Yeah,
guess when Stephanie's birthday was? It was
January
1/13/99.
Yeah.
So everything is corroborated by the fact that they all tied it in with
Yeah.
Stephanie's birthday. The Adnan lending Jay the car to buy Stephanie a present. Them going to Christie's house and talking about Stephanie's birthday. Later on, Jen took, when she got Jay from the park, from the mall, she took him to see Stephanie for her birthday. So it was all about Stephanie's birthday. So it was 1/13. What they had was a class schedule, and I know that you and I both have had many calendars over the years. And if you took my calendar from any month, half of those things never happened,
Yeah.
or they were changed
Yeah.
for whatever reason. And this particular night in Baltimore, they were expecting an ice storm. They didn't know when it was going to get there. But this class was originally scheduled from like 6 to 10 at night. So I think the instructor moved it up to the afternoon, because Christy has always said that she went to I think she called it a conference in the afternoon. There's no record of any afternoon conference. Susan Simpson pointed that out. So I think that class was moved up to the afternoon. So that's what
Correct.
that's what seems most logical.
I agree. And the quote recantation in the documentary is totally, it's so staged, it's not even funny. Because all she's saying is, well, I couldn't have missed the class. You say that now, but back then, how many classes did you miss?
Exactly. Plus, they pulled a fast one on her there. I don't know. I haven't dug deep into this. So people say that when the HBO producers showed her that document, they led her to believe that they were talking about a class where she made a B, but they were actually talking about a class. But if you look down on the form, there's the other class she made a C or C minus or something, and that was the real class that they're talking about.
Yeah. Yeah. All right. So anyway, again, this is not valid grounds for a motion to vacate. Because it's not evidence. And then Jay Wild's testimony is not reviled. Well, that's your opinion, Becky Feldman.
Right.
But it's not evidence. And unless you have Jay Wilds willing to come in and say, I lied about everything, I killed Hae, and Adnan had nothing to do with it, and I was just trying to get my ass out of trouble. And guess what? If you're going to call Jay Wilds a liar, you're going to have a hard time you're going to have a hard time with that story. Because if he's a liar then, he's a liar now. But yeah, Jay Wilds' testimony is not reliable. That's your opinion. Again, it's not evidence. Then they talk about Ritz's past misconduct, an exoneration in 2016 of a guy named Bryant, and a Cooper murder conviction being overturned in 2005. But again, that's not valid to Syed because there's no allegation that Ritz committed any misconduct in connection with the Syed investigation.
Exactly. In fact, he's never been convicted of committing misconduct. There have been allegations. He's a policeman. What do you expect?
Mm-hmm.
I think he was a policeman for 30 years. I mean, these people are going to suggest that the police framed them. That happens all the time. But Ritz was never ever actually convicted of anything, and several times his name was dropped from the lawsuit. So
yeah. All right. So, and then they want Syed released ROR pending state attorney's decision to retry or null pros the charges.
Mm-hmm.
I'm just making a note on Ritz real quick. I'm sorry.
Okay.
So that I have this because it'll be a great reference if I ever do this again. This is one of those cases that
it just comes up again and again,
and it kind of gives me PTSD.
I know.
To the West Memphis 3, and I'm like, I don't want to freaking deal with this anymore.
Less than a month, I'll be dealing with it for 10 years.
Yeah. So, response to the motion to vacate was filed by Syed on September 14th, joining in the SAO's request. Surprise, surprise, surprise. And again, writing for the sheep media who aren't going to question what you're telling them. On September 16th, 2022, an in-camera hearing is held in Judge Finn's chambers without notice to Young Lee. During the hearing, the court was provided with 2 documents that the parties claimed contained Brady material. Neither of these documents were included in the vacatur motion, nor were they entered into the record during the hearing, which if you're alleging a Brady violation, you should present the evidence of that Brady violation, and you should have to show how that information is material. Because there are 2 prongs to Brady. It's not only that you didn't get it, it's that it would have changed the outcome of the proceedings.
Exactly.
And I don't think that a person testifying that Adnan said he was going to kill somebody or make somebody disappear, because they would have to do that through the testimony of the witness who made the statement.
Right.
Then, that's not evidence. The note is not evidence, it's hearsay.
Exactly. Brady has become such a buzzword. I mean, anytime you get some of these innocenters, they want to say, well, there was a Brady violation.
Mm-hmm.
They don't even, I don't think they know that there's 2 parts to Brady. That something can be withheld, but that doesn't necessarily make it a Brady violation. It has to be shown that it would have made a difference.
Mm-hmm. But the problem is that, I've seen it with Rodney Reed. The defense is claiming a Brady violation, and they're claiming what that evidence would have proven, and so people just say Brady violation. This is what it proved, and it's been proven. It's like, no, you're missing several steps in this story, baby.
Exactly.
An order was entered on September 16th, 2022, setting the hearing for 9/19/2022. An email was sent on that date by Feldman to Young Lee at 1:59 p.m. Oh, God, this one makes me really mad. The court just scheduled an in-person hearing for Monday, September 19th at 2 p.m. Eastern Standard Time. Like, you couldn't tell the judge, hey, look, the victim's family needs to come from California, so let's not set this on the 19th. Let's set this next Friday, or let's set this for the Monday after. Because Becky Feldman is supposed to be looking out for Young Lee, even though she's now representing Adnan Syed as well.
Right.
She still should have been looking out for Young Lee and not let the judge set it, because she acts like she had no choice.
Exactly.
And, I mean, I've been in this business 40 years, and yes, there are times when you want to get a hearing as quickly as you can, but usually when you're doing that, everybody involved is on board and is involved, and their calendars are consulted, and we pick a time and a date when everybody is available. And we've had situations where we wanted to get something before the court, but we couldn't get it before the court as quickly as we needed to because one of the parties could not make themselves available. It happens. But, this is like she pretends like she had no say in it. It's an in-person hearing, but I asked the court for permission for you and your family to watch the proceedings virtually if you would like. So she was intending for them never to be there.
Exactly.
So if you would like to watch, the link is below. Please let me know if anybody from your family will be joining the link, so I will make sure the court lets you into the virtual courtroom. Please let me know if you have any questions. Security and media orders were issued by the court for the vacatur motion hearing set for September 19th, 2022. On the 18th, Feldman sent a text to Young Lee at 1:22 p.m. This is on a Sunday that says, just wanted to make sure you got my email about the hearing scheduled for tomorrow. I sent a video link in case you want to watch. Like, yeah, you want to watch. I mean, that is the most sadistic thing I've ever seen from a defense attorney in my life.
It's horrible. It's just horrible. She thought he would just take it laying down.
Yeah. No, that's what she wanted. She wanted him to take it laying down. And I have a thought on that, and I'll tell you. I'll bring it up later. So on the 18th, Young Lee responded to the text at 4:08 p.m. that said, yes, I got the email. I will be joining. Thank you. And then he went out and he found Stephen J. Kelly. He retained counsel on that date. Kelly is a victim's advocate in Maryland and DC, I believe. And he was retained to represent Young Lee at the vacatur motion hearing. On the 19th, Kelly filed a motion to postpone and demand for rights on behalf of Young Lee, seeking a 7-day continuance to allow Lee to travel to Baltimore and attend the hearing in person, and seeking unspent victim witness relocation funds from the SAO's office to pay for Lee's travel to Baltimore. So with the help of Mr. Kelly, Young Lee kicked Becky Feldman in the face.
Yeah.
He did not take it lying down. And
no, he didn't.
I have to say, Stephen Kelly did a masterful job because he did set this up perfectly. And he set them up in the trap and let them fall into it and impale themselves on the spikes. The hearing was held on September 19th, 2022. The motion for postponement was denied. Lee did attend via Zoom. Kelly was permitted to make a brief statement at the beginning, and then Feldman and Souter argued their motion. Nobody was representing Hae Min Lee or the Lee family's interests. Judge Finn read from a prepared order, which included an immediate release of Syed, then released the parties to a prearranged press conference. Feldman and Souter and Syed's advocates then leave the courtroom for a press conference. So they arranged a press conference.
That whole thing was scripted.
Yeah.
From the beginning to end. Everybody knew what was going to happen, including the judge.
Yeah.
She's the one I'm most mad at. I mean, Souter does what she's a defense attorney, so I guess she's doing what she's supposed to do. Marilyn Mosby's a crook, so she's acting in accordance with her nature. Rebecca Feldman, I don't know what was wrong with her. She was just somebody that was in a different place than she should have been, But the judge should have known.
I have to tell you, and this is my opinion, but I have found that these IP people are arrogant as shit.
I know.
They are so arrogant that it gets disgusting. I mean, the way she treated Young Lee was absolutely disgusting. He should have been told about the possibility of this for a week. She should have told the judge not to set the hearing on the Monday, to set it the following Friday. That would have given him time to get to Baltimore. But she didn't.
No, she didn't want it. She didn't want it in Baltimore.
She thought he would take it lying down, and he didn't. He kicked her in the face.
Exactly.
So then a written order is issued on the same date, 9/19. The judge says, in the interest of justice and fairness, the state's motion to vacate judgment of conviction in the matter of Adnan Syed as to indictment. I'm not going to bother with the the numbers. Count
Right.
1, murder in the first degree. Count 1, kidnapping, adult. Count 1, robbery. And count 2, false imprisonment is granted. She refers to the acquittal and the null pros from the earlier indictment after the trial, I guess, because the jury didn't render a verdict on those counts or acquitted him on those counts. She ordered that the defendant will be released on his own recognizance and placed on home detention with GPS monitoring with Alert Inc. And it is further ordered that the state shall schedule a date for a new trial or enter null prosequi of the vacated counts within 30 days of the date of this order. Then, in another arrogant, disgusting act by the state's attorney's office and Becky Feldman, on October 11th, 2022, they entered a null pros in the Circuit Court of Baltimore City based on the alleged exclusion of Syed by 2022 DNA testing. They didn't give Young Lee notice of this proceeding. They didn't give Young Lee the opportunity to appear at this proceeding. However, they were screwed because Young Lee had already filed his notice of appeal and begun that process, which will become an important issue later on. So then we go to the Maryland Court of Special Appeals, which is now the Appellate Court of Maryland. Young Lee was represented by David W. Sanford, Stephen J. Kelly, and Ari B. Rubin. Syed was represented by Erica Suter from the IP, Innocence Project, and Brian L. Savin, a public defender. Now, I want to know, why is he being represented by a public defender when he's got a free counsel? That is sketchy to me.
I don't know. I think she was a public defender, and then she got this job with the, what is it, the University of Baltimore Innocence Project? I'm not sure. I think she was his attorney originally, and then she got this other job, but I don't know much about that. I don't.
Okay. Well, I mean, I don't understand why she would, unless Brian's just trying to jump on the bandwagon, or maybe they're just trying to get some state funds to the public defender's office.
Could be.
Which is sketchy as hell. Why am I not surprised? Then the state's represented by Daniel Jawar and Carrie J. Williams. They're both with the Attorney General's office. And just to quickly, I didn't say this before. I should have said it before. There's a distinction. The state's attorney's office is the individual county by county, quote, district attorney. The Attorney General is the overall state of Maryland attorney. Now, another thing that I think was sketchy was this whole motion to vacate never consulted the Attorney General's office.
I know.
Aside from looking at their file, quote unquote.
He came out almost immediately and said that, he basically said it was a fraud. He basically said there was nothing to support it. The Attorney General was very quick to respond.
Yeah. I've got his press release from the 19th. So Young Lee filed his notice of appeal on September 28, 2022. An order issued on October 12th, 2022, denying Lee's motion to stay circuit court proceedings pending resolution of appeal. Denying the state's motion to strike Syed's notice of intention to respond and for temporary stay of proceedings, and ordering the Attorney General's office to respond to Syed's motion to disqualify the Attorney General as counsel for the state of Maryland and to strike the state as a party to the appeal within 15 days. That's when they're supposed to respond. And ordering Lee to show cause in writing within 15 days why this appeal should not be dismissed in light of the null pros filed with the circuit court by the SAO's office. On November 4th, 2022, Syed's motion to disqualify the AG was denied. Lee's response was deemed sufficient and the appeal was ordered to proceed. The clerk was ordered to transmit the record to the court. Appellant's briefing was set for December 9th. The state and Syed briefs were set for January 9th, 2023, and the parties were directed to brief whether the appeal was moot, whether the case, even if moot, warranted the court's exercise of its discretion to issue an opinion on the merits, despite the mootness, and the merits of whether the notice Mr. Lee received in advance of the circuit court's vacatory hearing complied with the applicable constitutional provisions, statutes, and rules. The appeal was scheduled for consideration in the February 2023 session of the court, and Syed's motion to strike Exhibit A to appellant's response and reply to response by appellant and the Office of Attorney General and motion to strike appendix to appellant's response was denied. Now, I couldn't find the Exhibit A the specific Exhibit A that they're referring to. Do you have any insight into what that might have been?
No, I don't actually. I'm just looking at that now. I don't know.
Okay. All right. Well, I will continue digging. I was
Okay.
digging on an old my desktop computer runs Vista,
Mm-hmm.
and
Oh, okay.
Google does not like it, nor
Okay.
does Mozilla Firefox.
Okay.
So my ability to search when I'm doing my notes, typing it on the desktop, is extremely hampered.
Okay.
So I will continue looking for that Exhibit A that he is referring to.
Okay.
Moving on December 5th, 2022, Syed's unopposed motion to correct the record was granted, and emails exchanged between Feldman and Lee on September 13th, 14th, and 16th, and the text messages from 9/18 were all made a part of the record. And this is the hilarious part. Syed thought this proved he got adequate notice of the hearing.
Yeah.
And it really exposed the atrocious treatment of young Lee and the Hae Min Lee's family as a whole
Exactly.
by Becky Feldman, who is now going to be the villain in my story.
Okay.
The appellant's brief was filed on December 9th, 2022 by young Lee. A masterful brief. It is such a wonderful stand taken for victims' rights,
Mm-hmm.
and especially pointing out the expansion of victims' rights in the state of Maryland, which is a wonderful thing.
Mm-hmm.
I wish Texas would pass something similar, but they haven't so far. Corrected record extract was filed on December 12th. The appellee briefs were filed on January 9th, along with amicus briefs. And in the the appellate court, there was appellee briefs by the state and Syed, and then amicus briefs in support of Syed by the National Association of Criminal Defense Lawyers and the Innocence Project and Center for Wrongful Convictions. On the 20th, an order was entered granting an unopposed motion to correct the record and entering Exhibits 1 through 11 to the state's motion to vacate, and Exhibit 1 from the vacateur hearing, which was an affidavit of Becky Feldman, were all made part of the record on appeal. The appellant's reply brief was filed on the 23rd. An order was entered on the 27th. Basically, the court wanted a copy of the null pros proceedings. And so young Lee was ordered to get a copy of that into the record, and the clerk was ordered to file that transcript by February 1st. The transcript was filed on January 31st. And then on January 31st, young Lee filed a notice of supplemental citation and motion to submit supplemental briefing based on or noting that Lee's rights were violated by the state's attorney and circuit court during 3 proceedings: the September 16th secret pre-hearing, the 9/19 vacateur hearing, where Lee received an unreasonable 11th hour notice and was given no opportunity to physically attend, and the court refused counsel the right to speak, and the 10/11 null pros hearing, when the state's attorney dropped the charges without notifying or hearing from Lee. Lee also moved to supplement his briefing based on those newly discovered facts. No order was ever entered denying or granting this, but on the 28th of March 2023, March is not a good time for Adnan Syed.
No, it's bad time.
I mean, all of those things have come out in March.
Mm-hmm.
The Court of Special Appeals, a panel of three judges, Graf judge authored the opinion, the majority, joined by Chief Judge Wells. And basically, the Court of Special Appeals at that time, they had just changed their name, I think. Anyway,
yeah.
Okay, no nitpicking. Because the court violated Mr. Lee's right to notice of and his right to attend the hearing on the state's motion to vacate in violation of 8-301.1D, we have the power and obligation to remedy that injury. Therefore, we vacate the circuit court's order vacating Mr. Syed's convictions and sentence, which results in the reinstatement of the original convictions and sentence. We remand for a new legally compliant, transparent hearing on the motion to vacate, where Mr. Lee is given notice of the hearing that is sufficient to allow him to attend in person. Evidence supporting the motion to vacate is presented, and the court states its reasons in support of its decision. Mr. Lee argues that at the remand hearing, he should be permitted to mount a credible challenge to the evidence supporting vacatur. To that end, he requests that this court appoint him as a limited purpose party in interest, or alternatively appoint the Attorney General's office or other suitable entity to challenge the evidence during a new hearing. That request is denied. We will exercise our discretion to stay the effective date of the mandate for 60 days from issuance of this opinion. That gives the parties time to assess how to proceed in response to this court's decision. Judgment of the Circuit Court for Baltimore City vacated. Cases remanded for further proceedings consistent with this opinion. Cost to be paid 50% by the mayor and city council of Baltimore and 50% by Adnan Syed. This is a good win for young Lee.
It is.
Not a full one, but I think it's also important to note that costs were assessed against the mayor and city council, i.e. state's attorney's office, and Syed.
Right.
So the dissent was by Berger, Judge Berger. In my view, this appeal was rendered moot by the state's entry of a null pros following the grant of the state's vacatur motion. I disagree with the majority that the null pros was a legal nullity. Nonetheless, because this case presents issues that are likely to occur and evade review, as well as matters of important public concern, I would exercise discretion to consider the merits. On the merits, I agree with the majority's analysis in Part 6 of the majority opinion, in which the majority held that Mr. Lee had no right to be heard at the vacatur hearing. Where I part ways with the majority on the merits, however, is with respect to the notice provided to Mr. Lee, as well as his rights to attend. In my view, the timing of the notice in relation to the hearing should not be considered in a vacuum, but rather in the context of whether the notice was adequate to enable the victim or victim's representative to attend. I would not find a violation of the victim's rights statute in this unique case when Mr. Lee was notified, albeit one business day before the vacatur hearing, and ultimately attended the vacatur proceeding electronically. I think that's ridiculous.
Right.
Reasonable notice is not one business day.
No, it would never be, especially for a person out of town.
Yeah. So even if he was in Baltimore, because one business day he's got to secure, getting time off from work, and especially when he's notified at 2:00 he's not notified at 8:00 in the morning on that business day. He's notified halfway at the end of the business day, with 3 hours left to the business day
exactly.
on Friday. So Judge Berger doesn't know what he's talking about. And of course, he was the hero to the Syed crowd. An order entered on May 2nd, 2023, denying Syed's motion for reconsideration. Then this went to the Supreme Court of Maryland. for a petition for writ of certiorari filed by Syed and an unopposed motion to stay issuance of the appellate court's mandate. That was granted on May 25th. Lee filed a cross petition for writ of certiorari on June 8th, 2023. The state answered the petition and cross petition on June 13th. Syed answered the cross petition on June 21st. A second order extending the previously issued stay was entered on June 28th. So the appellate court's mandate was stayed pending resolution of Syed's petition. The circuit court granted the writ and cross petition, or the petition and cross petition were granted, and the case was transferred to the court's regular docket as number 7 on September term 2023, and that was on June 23rd, 2023. Syed's brief was filed on August 2nd. An order granting an unopposed motion to permit filing of a supplemental record extract was entered August 10th. The supplemental extract was filed on August 15th. Amicus briefs were filed on August 28th in support of Lee by the Maryland Crime Victims Resource Center and the National Crime Victim Law Institute, and in support of Syed by Marty Tankliff and a bunch of other murderers who have been let out of prison.
Exactly.
And National Association of Criminal Defense Lawyers. And one of those is Nora Jackson, who I think is absolutely, totally guilty.
Yeah. Oh, yeah. Marty Tankliff, I'm almost certain he's guilty. He benefited from a kind of the business partner thing. That was just something, a red herring. I mean, he killed his father. I mean, he didn't have to kill the mother, if it was the business partner. So yeah.
Yeah, totally. And Nora Jackson, she killed her mother in Memphis.
Oh, her, yes. Oh, absolutely. Yeah.
Yeah. All right. So respondent's brief was filed on August 28th by the state of Maryland, and a respondent's cross petition brief was filed on August 28th by Lee. An amicus brief was filed on September 8th, 2023 by Survivors of Violence Clinic in support of Lee. So it's great. Mr. Kelly was able to marshal some amici to support young Lee's position, which is wonderful. Petitioner's reply brief and cross respondent's brief was filed on September 22nd by Syed. Syed's motion to strike argument by state of Maryland was denied on September 25th. A reply brief was filed by Lee on September 29th. Oral argument was held on October 25th. And then on August 30th, 2024, the Supreme Court of Maryland issued its opinion. And that was authored by Judge Beeren and joined by Judge Watts, Judge Gould, Judge Eves, and Judge Lynn, I guess Lynn.
Yeah, I'm a little confused about that because it was a 4-3. So let's see.
I have Beeren in there twice.
Yeah. Okay.
So let's see. Beeren, Watts.
Well,
Gould,
I think this Lynn A.
Eves.
Battaglia, I think she was actually on the dissent.
Oh, okay. It was hard to tell.
Yeah. I think it was Watts, Barron, Gould, and Eves.
Okay.
That was the majority. And I think Lynn, the retired judge they brought in to replace the chief judge because he had had a relationship before with the attorney general. So they brought in this retired judge, and I think her name was like Lynn A. Battaglia.
Okay.
Like that. Yeah.
It's hard to tell sometimes on the way they do the opinion.
Oh, I know.
It looked like Battaglia there was Battaglia, comma, and then it looked like there was a Judge A. Lynn, last name Lynn. That's why. Okay. So anyway, Beeren, Watts, Gould, and Eves. And I'm going to just read this is their holding. In an effort to remedy what they perceived to be an injustice to Mr. Syed, the prosecutor and circuit court worked an injustice injustice against Mr. Lee by failing to treat him with dignity, respect, and sensitivity, and in particular by violating Mr. Lee's rights as a crime victim's representative to reasonable notice of the vacatur hearing, the right to attend the hearing in person, and the right to be heard on the merits of the vacatur motion. The entry of the null pros did not moot Mr. Lee's appeal because we are able to provide an effective remedy to Mr. Lee for the violation of his rights as a crime victim's representative without violating Mr. Syed's constitutional rights to be free from double jeopardy. That remedy is to reinstate Mr. Syed's convictions and to remand the case to the circuit court for further proceedings relating to the vacatur motion consistent with this opinion. Those proceedings will go forward before a different circuit court judge. On remand, Mr. Lee shall be afforded reasonable notice of a new vacatur hearing, that is, notice sufficient to provide Mr. Lee with a reasonable opportunity to attend such a hearing in person. At a new vacatur hearing, Mr. Lee and or his counsel shall be permitted the opportunity to be heard, among other things, on the merits of the vacatur motion after hearing the entirety of the parties' presentations in support of the motion.
That's where young Lee really hit gold there, because the intermediary court said that he couldn't present evidence or
Correct.
question evidence, but the Supreme Court said, oh, he can. So Adnan, that's what's screwing Adnan, because he can't. If he had just let it go back to the circuit court at the time of the middle court's decision, Lee wouldn't have had that right, but he does now, and that's going to make it difficult for Ivan Bates to go forward with this.
Yeah. Continuing on, judgment of the Appellate Court of Maryland affirmed in part and reversed in part. Case remanded to that court with the direction to remand the case to the Circuit Court for Baltimore City for further proceedings consistent with this opinion. Cost to be paid by petitioner, Adnan Syed.
That's right. He pays it all this time.
Now, one interesting thing, they held that Lee does have a right to address the merits.
Right. I don't think he can present. I don't think he can present evidence. I think he can question.
That's the thing that worries me.
Right. Exactly. Why?
Because if they're not bringing Kevin Urich in to explain his note,
yeah,
he can't bring Kevin Urich in to explain the note.
Right.
But hopefully it will not be in front of a pro-defense judge who is going to just say, yep, I'm going to do what you tell me to do.
Yeah.
It'll be a judge who will try.
I think everybody's going to be on their toes. They're going to dot their I's and cross their T's, because, I mean, they've had 2 high court rulings on how to do this thing.
Mm-hmm. There was a dissent by 3 judges, Houghton, Booth, and Battaglia. Respectfully, I dissent. Well, Houghton wrote it, and Battaglia and Booth joined. Respectfully, I dissent. In sum, the majority expends much ink to posit the following. The entry of a null prosequi by the state did not moot the appeal by the victim's representative of an order vacating Mr. Syed's convictions under Maryland Code Annotated Criminal Procedure Article 8-301.1, the vacatur statute. A victim or the victim's representative has a right to be heard in person at a vacatur hearing, irrespective of the lack of reference to such a right in Criminal Procedure Article 8-301.1 or Article 47 of the Declaration of Rights, and the victim or a victim's representative has a right to reasonable notice of a vacatur hearing. And I will outline my positions below. And then, it's a long dissent about why they totally disagree with everything the Maryland Supreme Court did.
Yeah. I'm glad that it went the way it did.
It wasted a lot of ink on
in my mind. I was so afraid it would go the other way due to standing or something ridiculous like that. But
yeah, when the null pros went through, but I think the lucky thing is, based on my understanding of what I read in the majority opinion, the null pros went through after the notice of appeal was filed by young Lee. So it made it kind of look like another dirty deed.
Right.
Of the state's attorney's office trying to render his appeal moot by null prosing. So, And the Supreme Court of Maryland is like, no, we can't do that. So, but that is, yeah, I'm glad. And Stephen Kelly, anybody, he appeared on the Roberta Glass True Crime Report.
Yes, he
I
did.
would recommend anybody who, if you haven't heard it, listen. It's a great interview. I would love to talk to him as well. I may reach out to him at some point in time. I
Mhm.
want to see what happens though with I don't want to talk to him until after that procedure is over, because I don't want to risk anything with young Lee or
Right,
his
exactly.
position.
I don't think they've asked for reconsideration yet, and it's been almost a month, so I assume they won't
The
ask for reconsideration.
the deadline for they're going to ask, honey, they're going to ask for reconsideration. What
Probably.
have you not learned?
You're
They're
right.
going to ask for reconsideration. They're going to try to argue that it was all moot, and then if they don't ask for reconsideration, I expect that they are going to try to go to the U.S. Supreme Court
The
and try to
Supreme
get
Court
the U.S. Supreme
they won't
Court.
take the case. Yeah, they won't
They
take the
won't
case though
take it,
because
but
it's
it'll delay
delay.
everything
Yeah,
and keep
delay. You're
Adnan
right.
out of prison long enough to perhaps give him time to cut his ankle bracelet and go to Pakistan.
Yeah, that's right.
Because I mean, if he can't play the victim, as we saw in his presentation whenever, what was it, the Court of Special Appeals
Hmm.
decision went against him.
Right.
I'm surprised he hasn't come out with a presentation since the Supreme Court came out. So,
Yeah, I
yeah,
think
I think they're going to
he
ask
was
for
very unwise.
reconsideration.
He was very unwise to do that presentation. I think that a lot of people saw his narcissism up close when he did that thing. That hour-long or 2-hour-long
Hmm.
presentation.
Yeah. And hopefully that's going to come back to bite him on the ass.
I think so.
But what is your sense? Do you think Ivan Bates is going to even try?
Well, Ivan Bates is between a rock and a hard place. And I don't have any idea how he feels about Adnan today. Now, while he was trying to be elected state's attorney in 2018, he was vocal about being supported Adnan. He said that if he got a new trial, he would drop the charges. He wanted the HBO. He was on the HBO documentary saying pretty much the same thing. And then he wound up beating Marilyn Mosby in 2022. So now the case is back with him. If he's going to just drop the vacated motion, I think he can handle it. Nobody would
Yeah.
question. Well, nobody would think that was anything dirty there, but he can't possibly defend that motion, can he? I mean, because he's been so vocal. I mean, it's something that he just can't do. He's going to have to pass it on to somebody.
Yeah, and that's what I'm thinking. I haven't really said it on social media, but that's what I'm thinking because of his prior statements and stance. If he's smart and if he really wants Adnan to win, he should step away and let the court appoint somebody. But I would think, look at it and say, well, it's not even really supported by any evidence.
It's not.
So,
I mean, anybody that defends, unless they've got something different, unless they have found something else they can run with, nobody that cares about their career is going back into the court with that same evidence. I hate to call it evidence because it's not evidence, but with that same evidence, there's nobody that cares about their career that's going to go back into court with that, and no judge that's going to sign off on it.
Yeah.
So you asked me what I thought. I think this is what I really think. I think that Ivan Bates will drop the motion to vacate. And I think they're probably already working on a sentence reduction on that juvenile act, where if they were sentenced if they were committed the crime when they're under 18 and have served 20 years, I think that's what they'll try. Adnan, I don't think Adnan's going to show remorse, and I don't know how big of a deal it is. I think they're supposed to do it because they think the person has been rehabilitated, but we'll just have to see. Because Adnan has not been rehabilitated.
And
He won't take any. He won't even show remorse for it.
my sense though is that if they didn't do that, if they'd done that from the beginning, he would have been out of prison.
Oh yeah,
free and clear, but he would have been a convicted murderer.
Convicted felon, and he
that's
needs
what
to be a
he
convicted
doesn't
murderer.
want.
And here's this good thing for us, bad thing for them. If they had just given young Lee a week to get to Baltimore, that would have been the end of it, unfortunately. Now, because they were so much in a hurry, so
They were
rude,
arrogant.
arrogant, yeah. They went through all this, and of course gave people who with logical minds a chance to look at it. And now nobody is going to grant another him being out of void his conviction because of the stuff they brought up at that vacated hearing.
Well, I have to say Stephen Kelly did a masterful job at the hearing, teeing up this decision by the Maryland appellate courts. And he did a masterful job. His briefs in both courts were because you notice when you read the opinion how they talked about the evolution of victims' rights in Maryland and how important it was. So, yeah, he did a masterful job. If you're listening,
I guess we'll
Mr.
just
Kelly,
have to wait and see. Go ahead.
If you're ever in New Orleans, look me up. I'll buy you a drink, man. So
yeah, I just will just have to. Well, you're probably right that they will file for reconsideration. I think that's so silly. If the court just decided that you don't get any particular decision, then they're not going to turn it around in 30 days, are they? I mean, does that ever happen?
no, it's unusual. I mean, I have personal experience back when I first started with this one PI firm, personal injury firm. He lost a motion for summary judgment, and he appealed that to the First Circuit Court of Appeal in Louisiana. They denied his writ, and I wrote a request for rehearing, which found case law that he hadn't brought in during his opposition to summary judgment or during the initial appeal. And the First Circuit reversed themselves and granted the writ and reversed the motion for summary judgment.
Oh, okay.
And sent it back to the trial court for the case
It works
to proceed.
Once in a while then, but
every now and then you get, like I said, even a broken clock's wrong, right twice a day.
Right, twice a day, yeah.
Even a blind squirrel can occasionally find a nut.
Exactly.
But it does occasionally happen. I've seen, and I've been really disappointed because, they reconsidered and did a 180. But I don't think it's likely. But they're going to do it because it keeps the clock ticking.
Right, it gives them 30 more days, and then with the Supreme Court, if they file for cert, that'll give them another year.
Yeah.
Or almost, not quite, maybe. If they file it pretty soon, it'll be June.
Well, I don't know.
They'll deny that. Yeah, they'll deny the cert. It won't be June. It'll be pretty.
Because their term is going to start again in October.
Right.
So it'll probably be maybe the end of the year. Of course, they've got until December to file the writ with the U.S. Supreme Court.
Right. So it'll be decided much before the end of their next term.
Right. Yeah. It'll definitely probably, but it'll be 2025 before a final decision. But
will that be final?
it also, it keeps the whole motion to vacate in abeyance. So, but I think they have to wait for the mandate of the Supreme Court of Maryland. That's due on the 29th.
And Ivan Bates did do a news conference where he said that it would take him some time to decide what to do. So,
Yeah.
but of course, the filing for reconsideration in the Supreme Court, that has to go along. I guess they won't wait for Bates to
No,
complete his decision. No.
he's got to file. He's either got to file. He's got to file motion for reconsideration by the 29th.
Hmm.
If they issue the mandate, today, he's going to be SOL because
Hmm.
you have to file for reconsideration before the mandate. So, but yeah, they've got until the 29th, and the mandate issues in 30 days. So,
Okay.
reconsideration would probably be their next step on the 29th. 90 days after the mandate for the U.S. Supreme Court. So that'd be December 29th-ish, December 30th, December 31st. And then, yeah, to try and say, because they do theoretically have the whole defendant's constitutional rights balanced against victims' rights
Hmm.
argument to make, although I don't think they set it up in their pleadings or their briefs. But we can wait and see.
Oh,
Any
yeah.
final thoughts, Rob?
Well, I just wanted to say something more about Marilyn Mosby because I don't like her.
Oh, good. Okay.
And I just wanted to say something more about her because she was, she was put in her office by George Soros.
Hmm.
And it just so happened that the Freddie Gray case was going on about then, and she pledged to do all kinds of things to get him justice, and of course she failed at that. And there were just all kinds of things all over the period of her when she was in office that was very, very strange. Like she prosecuted this one defendant 5 times that she knew was innocent, but she did it because she was having a cat fight with the uh, prisoner's wife. But the thing I wanted to tell you about was that there was this other man in 2004. There was this guy named Tony DeWitt who was sentenced to life in prison for the murder of a girl in Baltimore the day after her 16th birthday. His conviction was overturned in 2015, I think, after he had allegedly discovered an exculpatory document in police files that had not been made available to his attorneys at the original trial. He filed suit against officers of the Baltimore Police Department alleging malicious prosecution. Well, Ms. Mosby's decided she's going to take this seriously, and she gives it to a person in her office by the name of Cynthia Banks, she was just like Rebecca Feldman. I mean, she was just in the up, and so they went on with it, trying to get that case for. I think they did vacate his conviction, but when he applied for compensation, a federal judge threw out the civil case because private attorneys representing the officers proved that the document that resulted in his exoneration was a forgery. The document supposedly was a police memo that Mr. DeWitt said that he obtained through a public records request that described an interview in which a witness identified another person as the killer. And according to news reports, the authenticity of the document was not challenged by the assistant state's attorney, Cynthia Banks. Ms. Mosby later appointed Ms. Banks, and she promoted her for all this stuff. And she promoted her to the chief of the felony trial at the state's attorney's office. So she has a long history of these cases where I have no idea why she did it, but Adnan's is not the only case.
Hmm. Yeah. I think I had heard something about DeWitt, and I remember reading the federal judge finding that the document was a forgery
To the
and
best of
thinking,
my
well, that
memory,
doesn't look
yeah,
good for Marilyn Mosby's office.
no, it doesn't. To the best of my memory, and I don't have my material in front of me right now, but the best I'm paying, he got out of jail, he got out of prison, and at that time, Maryland didn't have what they have now, so he got a few, maybe I don't know, maybe $100,000, $200,000. Now in
Hmm.
Maryland, if you get out of prison, and say you've been in prison 20 years, you get 20 times the average income. They have this whole setup now but at that
Okay.
time they didn't do that, so he got much less than he thought he should have. So he files this petition for additional money under the new act, and that's when all this was uncovered uh, about the document that was a forgery, and Mosby had given it to Cynthia Banks to process, and so forth and so on.
Yeah, and that's what Adnan's angling for as well.
Exactly. Oh, it'd be interesting to see. I hope we never see this, because I hope he remains convicted forever. But to see how much or how narcissistic he is, will he ask for $2 or $3 million? Which,
Mhm.
if he was
He
successful, I
won't,
think
Rob,
the
he won't
median
ask, he will demand.
demand, because I think the average income in Maryland today is $89,000, I believe, times he was in prison 23.5 years. It would be
Mhm.
$2,091,500. But I don't know. We'll
He
have
will
to see
demand
about
it.
that. It
So,
probably will. I just don't want this case to go down in history with new information. I want it to be the original information. I want the
mhm.
conviction to stand, and
Yeah.
that's my whole purpose of.
I think that's why he was so pissed and did the press conference after the
Mhm,
Court of Special Appeals,
mhm,
Appellate Court, because he
exactly.
knew he wasn't going to get that money.
Right.
So he's, alleging um, people should be investigating the prosecutors and police and all this stuff. So, no. And also, I think he's trying to poison any jury pool if there's a new
Mhm.
trial. So, all right. Well, I think that's our
Yeah, I
show, I
think we've
guess.
had a good session. I think it's been
Yes,
a
we
lot of
sure
fun.
have.
Thank you for having me.
Thank you for taking your Sunday and being here, and I really do appreciate it, and especially in Kyle's absence, because otherwise I'd have to be sitting here talking to myself.
Oh my goodness. Okay.
So,
So we
all
have to
right.
wait have to wait a minute or two for the recordings on this to upload, don't we? We can't cut off immediately. Is that right?
No,
What?
no,
Well,
I'm gonna read my outro and play my
mhm.
music, and then I can end the recording.
Okay.
But if you're ready to call it a day, you certainly are free to.
I'll just wait till the end, because there's something with StreamYard where they don't upload the recording currents on both ends, and they don't upload it to.
Okay.
Yeah, I
Um,
don't know.
I just switched from Zoom to StreamYard because Zoom was not stable.
It wasn't.
No, not on my system. So, but this has been much better. All
Okay.
right. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and guest co host today, Robb Chadwick. If you like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'Brien L. Ann. Kyle and I will return in 2 weeks for episode 15, State of Oklahoma versus Philip Dean Hancock. Hancock's November 2023 execution was preceded by controversy, including claims by our or my least favorite former Oklahoma legislators who claim that Hancock's brutal murder of two men was an act of self defense. We'll look at the 2001 murders of Robert Jett Jr. and James Lynch, the evidence against Hancock, his trial, direct appeals, and state and federal post conviction claims. Then we'll talk about the efforts to stop his execution with a request for DNA testing to bolster his claims of self defense. Until then, have a great 2 weeks and stay safe.